Hello, my name is Matthew Beresky, and I am a staff attorney with the Rocky Mountain Victim Law Center. Specifically, I work with victims of crime in our Victims' Rights Legal Services program. Today, I will give you a short overview of some of the protection orders that are issued in the state of Colorado, specifically criminal and civil protection orders. There are other types of protection orders that may be issued by Colorado courts in family and civil cases that I will not discuss here. This presentation is for informational purposes only. Any opinions presented in this presentation are those of the author and not intended as legal advice. If you have any questions or believe that you have a legal issue, please seek the advice of a lawyer immediately. The first type of protection order that I'm going to talk about today is commonly referred to as a criminal protection order, or sometimes referred to as an 18-1-1001. 18-1-1001 is a Colorado statute that provides legal authority for enforcement of criminal protection orders. Juveniles who have criminal cases may have similar protection orders with similar provisions that would be issued under the Children's Code rather than the Criminal Code. Criminal protection orders are issued in every criminal case. They prohibit the conduct of the defendant. At a minimum, the protection order prohibits a defendant from harassing, molesting, intimidating, retaliating against, or tampering with any witness or victim of the charged crime. A judge may modify the protection order to include many other provisions. A sample of those provisions may include an order to vacate or stay away from the home of any victim or witness, and to stay away from any location where the witness or victim is likely to be found. This means that in addition to staying away from the home of the victim or witness, the defendant must also stay away from the work location of the witness or victim and any other location that the defendant reasonably knows the witness or victim might be. The judge can also order that the defendant have no contact with a victim or witness. This means that the defendant cannot contact the witness or victim with any communication method, including through social media or third parties. A protection order can also prohibit a defendant from possessing or controlling firearms or other weapons, and can prohibit the use of alcohol or any other controlled substance. A criminal protection order can also prohibit the taking, transferring, concealing, harming, disposing of, or threatening to harm any animal owned, possessed, leased, kept, or held by any alleged victim or witness. The judge may make any other orders that it deems appropriate to protect the victim or witness. This means that the court has broad discretion to craft the protection order to keep the witnesses and victims safe throughout the criminal justice process. A violation of any provision of the protection order may result in further criminal charges and could be considered contempt of the court. The court may modify or dismiss a criminal protection order if it deems it appropriate to do so. If the charges in the case implicate the Victims' Rights Act, however, then the victim has the right to be heard prior to the court modifying or dismissing any no-contact provision within the protection order. Finally, a criminal protection order remains in effect throughout the entire criminal justice process. This means that the protection order is enforceable throughout post-sentencing to include probation and parole periods. A civil protection order is different than the criminal protection order because it is not a state action and is usually brought by private citizens against other private citizens. A person bringing the protection order is commonly referred to as a petitioner, and the restrained party is commonly referred to as a respondent. Notably, a civil protection order does not require that any crime be reported to law enforcement or that there is any criminal prosecution underway. A civil protection order must be filed in either the county in which the incident occurred or in the county where either of the parties resides or is employed. When a party seeks a civil protection order, the court must set a hearing at the earliest possible time, and the hearing shall take precedence over all other matters. The hearing will be ex parte, meaning that only the petitioner will make their case for why they need a protective order. In the ex parte hearing, the judge must find that there is imminent danger to the person seeking the protection order. The court must not consider the time between the alleged act and the seeking of the protection order. If the court issues a temporary protection order after the ex parte hearing, then a judge will set another hearing at which the respondent may appear to show why the protection order should not be made permanent. It is the responsibility of the petitioner to have the protection order, along with supporting documentation, served upon the respondent. The petitioner must comply with the rules surrounding service and serve the respondent personally. In many jurisdictions, the sheriff's office may provide service for a nominal fee, or if the protection order is domestic violence related, service should be free. If the civil protection order requires that the restrained party leave the home of the protected party, then the court may allow a one-time entry into the residence of the restrained party in the presence of law enforcement to get undisputed personal effects that are necessary for the person to maintain a normal standard of living during the period prior to the permanent protection order hearing. At the permanent protection order hearing, the judge will examine any evidence that has been presented to the court, to include testimony by the parties and any other evidence submitted. If the court finds that by a preponderance of the evidence that the restrained party has committed acts that would allow for the issuance of a temporary protection order, and that unless restrained, the respondent will continue to commit such acts or acts designed to intimidate or retaliate against the protected person, then the judge will make the temporary protection order permanent. A civil protection order can prohibit many types of activities, to include threatening, molesting, or injuring any other party or minor child of the parties, restrain any contact between the parties, to include minor children, exclude the restrained party from a shared home or the family home, award temporary custody, care, and control of the minor child for a period not to exceed 1 year, restrain the respondent from protected persons, place of employment, education, or engaging in behaviors that would impair the protected person's employment, educational relationships, or their environment, and any other provision that the court deems necessary for the protection of the protected party and any minor child or animal within the protected party's possession. Violation of a civil protection order may result in criminal charges, and the protected party may be able to bring a contempt action against the restrained party that could result in jail time or continuous fines, or both. Thank you for listening to this presentation. Again, this video is for informational purposes only and does not cover every aspect or legal information about protection orders. If you have any questions about protection orders, please contact an attorney for further legal advice.